We'll begin our discussion of fiduciary duties. We're entering our second topic in agency, and that is the relationship between the agent and the principal. And the relationship between every agent and principal is one of fiduciary duty. Just as a format for what we'll be discussing, we are first talking about what effect the existence of an agency has between the two parties themselves, the principal and the agent. Separately, and in a separate podcast, we are going to talk about what effect that relationship has on third parties. In other words, not the principal, not the agent, but somebody else. For right now, we're back to the relationship between the principal and the agent, and that is one of fiduciary duty. The definition of a fiduciary duty, and as we've seen from previous discussions, there are lots of relationships, but agency is simply one example of a time when there is a fiduciary relationship. A fiduciary relationship is one of trust and confidence. Agents and principals have fiduciary relationships by definition. Just to remind you of fiduciary relationships, I think we discussed in class how to create one, but to review, suppose that you had a wonderful mother and your mother says, "Sugar, I need your signature on this. The bank's about to close. I have to get this there before they close. You don't have time to read it, and I don't have time to explain it to you. Just sign it." Assuming that you have a good relationship with your mother and you trust her, you're simply going to sign it. On the other hand, when you go to a car lot to buy a used car and the car dealer says, "Sugar, you don't have time to read this, and I don't have time to explain it. My manager's going to leave at 5 o'clock and you just have to sign." Are you going to sign this? Of course not. You're not an idiot. So what is the difference between these two things? The words are identical, but in one case we will very likely sign, and in the other case we won't. Why? Because when our mothers ask us to sign something, we're assuming, if we are lucky enough to have good mothers, that her interests are to promote our welfare or our family's welfare, and those are also our interests. We want someone to promote our interests or our family's interests. Whenever it is presumed that you have the same interests, you have a fiduciary relationship. On the other hand, when you go to buy a used car and you're not an idiot, you know that the car dealer and you have different interests. The car dealer wants to make a lot of money and you want to spend a little money. There's no fiduciary relationship there. So think back on the definition of an agency. An agency is created whenever there is an agreement that the agent will act for the benefit of the principal. Stop. The agent agreed to act in the principal's best interests. They are presumed to have the same goals. Therefore, there is always a fiduciary relationship with any agent and principal. Now, I'm going to start with the duties the agent owes the principal and then talk about the duties that the principal owes the agent. The first duty an agent owes a principal is to avoid conflicts of interest. A conflict of interest is whenever the agent and the principal have interests and they're not the same. Suppose that you hire someone to represent you in buying something. It is assumed that the agent is acting for your benefit and will be trying to get the best price they can get and the best deal they can get. What if the agent, in fact, was acting for herself? She's buying this for herself. Well, there's a conflict of interest here. You can never act with a conflict of interest, at least not legally permissibly, unless there's been a waiver. A waiver requires, number one, that the principal be notified of all material facts, and number two, waive the conflict. What are the material facts? Material in this context means significant. It means facts that either would affect your decision to enter a contract or facts that would affect the price. Suppose that you buy a house and the seller's agent says, "Hey, I can represent you too." Why might the seller's agent want to do that? Well, guess what? Because that way she will make the full commission. She doesn't have to split it with someone who's representing the buyer. Is there a conflict of interest when the agent acts to represent both the seller and the buyer? Well, sure. because the buyer wants to pay as little as possible and the seller wants to get as much as possible for the house. That's a conflict. Is it possible that maybe you might want that agent regardless of that? Well, sure, if you think that you can adequately protect yourself against that conflict, for example, by researching for yourself what the important terms would be and the price and any other terms that might be important for you, and if you think that might actually work to your advantage to have the agent represent the both of you, then it's possible you might think that. Then you may want to waive that conflict. But that's the principal's choice and not the agent's. So if the agent doesn't disclose that there is a conflict, then there is a breach of fiduciary duty. Before we get further on fiduciary duty, I just want to warn you. Courts take this duty so seriously you can't imagine. Let me give you an example of how seriously courts take breaches of fiduciary duty. Oh, and incidentally, that is the name of the cause of action, breach of fiduciary duty. Here's what a court would do. An example, and this is a true story. Two partners, and let's just pick a couple people from class. Let's say Diana and Wentao jointly own a business as partners. They jointly own a racehorse and they're going to sell that horse in an auction. For those of you who have never been to an auction, what happens is someone puts forward whatever it is they're selling and they start the prices at some relatively low point, and they'll say something like, do I hear an offer of $15,000? And if somebody bids this, it is the equivalent of someone offering to pay $15,000. And will the auctioneer accept that offer? And of course, if you've ever heard an auction, they don't actually speak that way in English. They say 15, 15, 15. But anyway, the people who are there understand that that means, are you willing to make an offer for $15,000? Now, will the auctioneer accept that bid or offer of $15,000? Well, only if he doesn't get any higher bids and there's no other minimum on the amount that the horse will sell for. So then what he will do is to say something like, do I hear $16,000? And when they say it's getting bid up, someone is bidding it up, that's what they're talking about. The auctioneer is going to keep going up and up in price until finally it can't go any farther. So let's say it keeps getting bid up and now it's $25,000. And the auctioneer will say, do I hear $26,000? But there's no one who will pay $26,000. Then he will look at whomever offered to pay $25,000 and say, sold for $25,000. Now, back to our hypothetical with Diana and Wentao. This particular case involved a mare in foal, meaning a pregnant horse. So when you're buying a pregnant horse, you're kind of getting a 2-for-1 deal. You're getting the mom and you're getting the baby as soon as the baby is born. Well, Diana, although she is partners with Wentao and is selling the horse with Wentao, actually wanted to buy that horse back herself. Would that be okay? Well, it is a conflict of interest, isn't it? Because buyers and sellers, as we've discussed, have different interests. One wants to pay as little as possible. One wants to get as much as possible. So Diana didn't tell Wentao that she was going to get her sister, let's just say her name was Joanna, to secretly bid on that horse on behalf of Diana. It was really Diana who was bidding on the horse. Is there a conflict of interest? Yes. But are there any damages? Suppose that Joanna's bid on behalf of Diana was the highest bid. Has Wentao been damaged by that? Well, no, actually. If anything, Wentao benefited by the conflict of interest because the price was higher than it would have been if Diana had not secretly been bidding the horse up. So if someone had been willing to pay more for that horse, they would have bid a higher price, and they didn't. So in fact, Wentao was not financially damaged by Diana's breach of fiduciary duty. Rather, he was benefited by the breach of fiduciary duty. In the case of Wentao versus Diana for breach of fiduciary duty on the basis of conflict of interest, will Wentao win or lose? If this was just a regular breach of contract case, Wentao would lose because if you can't show any damages, why are you wasting all of our time? you lose. That's true in all cases except breaches of fiduciary duty. A court will make an award in Wentao's benefit even though Wentao didn't lose any money. Why? Because courts take fiduciary duties really seriously, and they assume, number one, they really want to punish a scumbag like Diana, and this is sort of a form of punitive damages, although they don't call it that. And number two, they assume that there may be a secret benefit on the part of that agent who is breaching her fiduciary duty. And they observe that people in agency relationships can sometimes hide some of the benefits that are going on, and they will assume that the only reason that Diana hid the relationship was because she must have been benefiting secretly, or else why would she even do this? In this particular hypothetical, that is what turned out to be true. Apparently, and I don't know why this is true, I'm just passing this along, but apparently with racehorses, if the mare is pregnant with twins, twins tend not to do well as racehorses. So a week before the auction, Diana had been going around and passing around a false rumor that the horse she was selling with Wentao was pregnant with twins. And this was completely false. What happened to the price, however? Well, it depressed the price. So Diana actually really did benefit because of her breach of fiduciary duty by passing a false rumor and depressing the price. Again, it's just an example of how agents and principals sometimes have the ability to manipulate deals, and courts will therefore assume that there are always damages in breaches of fiduciary duty cases, and they'll be very liberal in awarding such damages. By contrast, in breach of contract cases and in most tort cases, be very conservative. But with breach of fiduciary duty on damages or other remedies, be liberal. Go back to our case again with Diana and Wentao. Suppose that the two of them wanted to sell the horse, but Diana just wanted to buy it. Couldn't she just have approached Wentao about it and said, I'd like to bid on this horse just for myself? And wouldn't an honest person have done that? Couldn't Diana have gone to Wentao and say, look, I understand you want to sell the horse, but I'd like to buy it, and see whether he's willing to waive the conflict? Why not try? It's actually common for principals to waive a conflict because they perceive it as being in their best interest sometimes. In the real world, when in doubt, if there is even a possibility of a conflict of interest, disclose it. And of course, it's easier to prove agreements if they're written rather than oral, so cover yourself. Have it written down. I've represented parties who are on different sides of litigation or on partially different sides, let's say different defendants. For example, many years ago, the MGM Hotel in Las Vegas burned, and this was a long time ago, which is how old I am. I represented one defendant, and I switched firms, and that firm represented a different defendant in the same lawsuit. Does my new client like it that I represented a different defendant in the same litigation? Actually, yes, they loved it because I already knew all the facts. I knew the history of the litigation. So I was saving them money because I didn't have to bill them for a bunch of time to come up to speed on the lawsuit. I already knew the lawsuit. Did my old client mind that I was representing another defendant? Well, no, they didn't, honestly, because the two defendants' interests in this particular case were so aligned that it actually worked to their benefit to have me in there. So when in doubt, always disclose the conflict and see if the parties are willing to waive it. Incidentally, whose waiver would I need? My former client or my new client? It's a trick question. The answer is both, because client number one and client number two were both at different times my principals, and therefore I would need both of them to waive that conflict. The second duty that an agent owes a principal is to avoid self-dealing. This is a big overlap with the concept of conflicts of interest, but I still want to list it because sometimes you will see a court using it. With the previous example that we used with the thoroughbred horse, it would also be an example of Diana's self-dealing. But the notion could involve other conduct as well. When the client pays the agent, the money belongs to the principal. What if the agent just pockets it? That's self-dealing. They're not supposed to steal from the principal. It's a breach of fiduciary duty. The third duty an agent owes a principal is confidentiality. And that includes anything that is understood to be confidential within that agency relationship. The agent must honor that confidentiality, and that duty exists during the agency, and it may exist even after the termination of the agency. Depends on the scope of the confidentiality. So once the deal is over, obviously you don't need to maintain any confidentiality once the facts are out. However, be careful, because in the duty of confidentiality, you need to be careful with the scope of that duty. Oftentimes, those of you who are going into professions, for example, accounting, financial services, healthcare, you'll find out a lot of information from your principals. A CPA, for example, may find out important financial information from one client and also from another client. And the information from one client might actually benefit a different client. Can they disclose it? Certainly not. They have to make virtual barriers among the clients to maintain that confidentiality. And just a quick review, is there an agency relationship between a client and a CPA? Is there an agreement that one will act for the benefit of the other at the principal's direction or control? Yes. Who's the principal? Who's the agent? Well, the client is the principal because the CPA is supposed to act for the benefit of the client. Be careful, because sometimes with agency relationships, we assume that the person with greater expertise in that area must be the principal. This is often wrong. When you go to your physician for medical treatment and you say, gosh, I have this pain, is there an agreement that one will act for the benefit of the other at the principal's direction or control? Yes. The agreement is that the physician will act for the patient's benefit at the patient's direction. Again, people sometimes mistake this and say, no, the doctor's making the decisions. Wrong. The doctor's making the recommendations. The final decision is the patient's. So if the doctor says to you, Joshua, you need to have your appendix removed, whose decision is it, Joshua's or the doctor's? Do you see what I mean? Joshua is the principal, the doctor is the agent. Okay, now you see a subheading here under confidentiality called covenants not to compete. And you see it says NB. NB means, well, in Latin it stands for nota bene, meaning pay attention. A covenant not to compete and a covenant is just a provision, an agreement. And oftentimes, in fact, for any of you who have employee manuals, take a look at them. There might be a covenant not to compete in there. What it may say is that you're agreeing as an employee of whatever the company is that you will not compete against your employer. Are those binding? Well, they're certainly valid while you are employed there. They are valid during the course of the agency. But are they valid subsequent to the termination of the agency? Very commonly, it will say something like, you agree that you're not going to, well, for example, sell insurance for First American Life Insurance Company, and you will not compete against us during the course of your agency or for 1 year subsequent to the termination of your agency. Well, why would the principal want that? Well, it's clear enough, isn't it? You're going to find out all about their product, their pricing, who their clients are, and they don't want you to take that information and then quit tomorrow and compete against them with another insurance company. They don't want you to be able to do that. Do they have a legitimate interest in keeping that information secret? Well, sure, those are really important facts that relate to their business competitive advantage. How much will they charge? What are the particulars of the policies they have? Who are their best clients? How much are those clients paying? Wouldn't a competitor want to know those things? Because it would be easy to undercut First Insurance Company by just going slightly below that and capturing the business. Is a covenant not to compete valid? The general answer is, and the majority rule in most jurisdiction is, It's valid if it's reasonable in scope and duration. And by reasonable, we mean it addresses reasonable business concerns. If we say you can never sell insurance again for the rest of your life, that isn't really aimed at First Insurance's legitimate concern about confidential information escaping. That's really trying to say, you have to work for us forever. You're like our slave. You can never work for anyone else. And no court anywhere will enforce that because it's anti-competitive. Remember, with our discussion of legality, courts are reluctant to enforce agreements or will refuse to enforce agreements that reduce competition. And this example is one that reduces competition. If you basically have to work for the same company as long as you work in that industry, that reduces competition and is not designed to further any legitimate business interests. So in determining whether a covenant not to compete is reasonable in scope and duration, look at what activities are limited. For example, if the covenant not to compete said you can't work in any industry at all for 1 year after you leave our company, a court would say that's not reasonable in scope. How are you threatened if this person goes and works in some totally unrelated industry? You're not. So they would not enforce that. Or if the covenant not to compete said you cannot work in the insurance industry anywhere in the US for 10 years, a court would say that's not reasonable in scope. 10 years is a long time. You can't still have any legitimate business interest in protecting most business secrets for that long a period of time. However, and here's the kicker, California has a statute saying that a covenant not to compete after the agency ends, and unless it involves the sale of a business, cannot be enforced in California. So let's again suppose that you're an agent for First Insurance Company, and there's an agreement that you will not compete for a period of 1 year after you terminate that agency. If you're in California, that is not enforceable. You can quit today and compete against them tomorrow. There's a statute that permits that, but you still have a duty of confidentiality. You can't release former information by your principal whenever you wish to. The only exception, and as I just mentioned, involves the sale of a business. So let's say that you have a Pita Palace restaurant on Reseda Boulevard. Suppose that you buy the Pita Palace, and this guy's been around a long time and he knows a lot about the market and he knows about running this fast food place, and you may want to put in a covenant not to compete. For example, if you want him not to open up a competing pita shop in a reasonable distance, let's say a mile, if he's selling you the business, you could enforce that restriction against that particular seller. But again, under California law, if it's simply an employee or other agent signing a covenant not to compete, those are simply not enforced after the termination of an agency. The next duty an agent owes a principal is the duty to use reasonable care and skill, and this is just what it sounds like. It doesn't mean that the agent is going to be liable for breach of fiduciary duty whenever they make a mistake. It does mean that they have a duty to act reasonably. If you use reasonable care and skill, you will not, as an agent, be liable. However, principals can go after somebody, an agent, who was not acting reasonably under the circumstances, and the principal can demand to be indemnified. Indemnified means to be reimbursed, to be paid back. My favorite story for this is when I was in college and my sister and I were working at a donut place. You may not have known all about donuts, and it's been decades since I have even eaten a donut because working there completely cured me of donuts. But there are two kinds of donuts in the world. There are cake donuts, which are kind of dense, and then there are yeast donuts, which are kind of gushy. Like a glazed donut is a yeast donut because it's bigger and fluffier. And there are two kinds of flour that they're using because yeast donuts have yeast in them, which makes the donut rise. With cake donuts, which again have a lot of flour in them because they're very dense, well, someone was working with my sister during my sister's shift, and they were making the recipe for cake donuts, so they were using a lot of flour, but she was making it using yeast flour, so it's a ton of flour, and it's the kind that rises. She was making it in a 5-gallon bucket, and she realizes that something's gone wrong because the dough in the bucket's getting bigger and bigger, and soon there are 2 buckets, and it's still rising, and then there are 4 buckets, and then there's 16 buckets, and by now the coworker's just crying, and when the manager finds out, he fires her. Is that a wrongful termination of the agency? Did he have the power to fire her? Well, the power to terminate an agency is always there. Did he have the right to fire her? If a reasonable person would not have made that mistake by using the wrong flour, then yes, the employee has breached her duty to use reasonable care and skill. Could the manager go after her and say, that cost $183 you wasted in flour because now all that dough is worthless and I'm taking it out of your paycheck? Technically, and this is an extremely regulated area of employment law, so definitely don't do this before checking with a specialist. But technically, yes, that's a breach of duty not to use reasonable care and skill. You tend not to find this occur much, but it can sometimes happen. The next duty an agent owes a principal is the duty to account. This is the same word source, of course, as accounting. When money comes in or goes out through the agent has a duty to keep track of it, to keep receipts, to keep records, to be able to report. The duty to account for the money. And finally, there's a duty to communicate. You'll see in a future podcast how once a third party tells an agent something, it's the same as if the principal found out at that moment, and therefore the agent has a duty to communicate that information relevant to the agency to that principal. Suppose that you go to your apartment manager where you live and say, here, I'm handing you my written 30-day notice to tell you I will be leaving in 30 days. However, the apartment manager fails to give that notice to the apartment owner. Did you make that notice effective? Yes, because the moment you handed the notice to the agent, it was the same as if you had handed it to the principal. The principal has chosen that agent to act on their behalf. Now, suppose the apartment manager didn't communicate with his principal, i.e. the apartment owner. Well, that's not your problem. That's the principal's problem. You don't control the agent, the principal does. So the notice was effective the minute you handed it to the agent. The agent has a duty to communicate with the principal. Let's move on to duties that the principal owes the agent. There's a duty to compensate the agent based on whatever the agreement was for compensation. There's a duty to reimburse and indemnify the agent when the agent incurs expenses that were reasonably necessary to perform the agency. The principal must reimburse that or indemnify, meaning pay back. And a duty of non-interference. The principal has to stay out of the agent's way enough so that the agent can get the work done. Sometimes the principal interferes so much that the agent can't finish the job, and that would be a breach of the principal's fiduciary duty. Finally, let's talk about remedies for breach of fiduciary duty. And again, err on the side of finding a remedy whenever you see a breach. What remedies could there be? Well, there could be damages. So the cost of the ruined flour if you worked at the donut shop. Another remedy might be termination of the agency, ending the agency, firing the employee. Injunction. An injunction is when the court is ordering someone to do something or to stop doing something. So you could have an injunction, for example, against an agent from releasing confidential information. I want to talk for a second about agency at will and agency for a term. This comes up more when we talk about employment law, but I just want to give you a heads up. Employment at will means you are employees for as long as the principal and the agent will it. So let's say, for example, that Ahmed works for Disney. Now, can Ahmed terminate that agency? Can he quit? Sure. Does Ahmed need a good reason? No, he can quit just because he doesn't want to do it anymore. Good reason, bad reason, doesn't matter. It's his business. How about Disney? Can Disney terminate Ahmed for a good reason, a bad reason, or no reason? In a pure common law employment at will, the answer is yes, they can. There are some limits on that, as we will discuss when we get to employment law, but in employment at will, the technical answer is yes. There are a lot of restrictions under current employment law that we'll discuss later. How about employment for a term? Well, let's take me for example. Can I just say, I'm done. I'm not finishing out this semester. I've had it. I quit. Do I have the power to do that? Am I an agent at will or an agent for a term? Well, I'm an agent for a term. The university has a contract with me. I promise to stay for the entire academic year. I have the power to terminate the agency, but I don't have the right to do it because I promised I wouldn't. Therefore, it would be a breach of my duties if I terminated early. However, with breach of fiduciary duty, even if I were an agent for a term, as I am, if I breach my fiduciary duties, does my employer, the state of California, have the power to terminate the agency? Yes, they do, because I breached my fiduciary duty. So compare the power to terminate the agency with the right to terminate the agency. Everyone has the power to terminate their agency, but if they're an agent for a term of time, they may not have the right to terminate. Post-termination relationships, as we mentioned before, some fiduciary duties may continue. Confidentiality typically continues even though the relationship may have terminated. And I want to give you one more piece of information, and that is, even in an employment at will situation, in many states they imply that the principal has a covenant of good faith and fair dealing, meaning they won't terminate people arbitrarily for no reason. They're promising to act in good faith. They're promising to deal fairly. So this is one theory that you can use in some common law jurisdictions that follow employment at will.